Hello, I'm Barbara Ash. I'm Executive Vice President of the Montgomery County Chamber of Commerce, President of the Chamber's Foundation, and National Director of the Veteran Institute for Procurement. On behalf of these organizations, I would like to welcome you to today's webinar, Decoding CARES Act Section 3610 for Government Contractors. Section 3610, part of the third federal COVID-19 relief bill, allows certain federal contractors to seek reimbursement. Today's panel of government contract experts will discuss what this provision is, how you can take advantage of it, and what questions remain regarding its intersection with the Paycheck Protection Program known as PPP. The slides and audio from today's webinar will be made available on the Chamber of Commerce VIP and the VIP resource page following today's broadcast. Please submit your questions throughout today's presentation. We will try to address some of them as we go through the webinar. And any questions we can't get to, we will certainly submit them to our presenters. And following the broadcast, we will send them out to you when they are available. Now, prior to introducing our esteemed panelists, I would like to start with some polling questions, which will help them adjust their remarks to the audience. If we could have our first polling question. Are you aware of how to seek relief using Section 3610 provision of the CARES Act? Please select 1, yes or no. Oh, okay, it's split, about half and half. Okay, that's helpful. We're going to go to our second polling question for today. That question is, have you discussed relief using Section 3610 with your federal customers? Please answer yes or no. Oh, so about a third have already discussed them with their customers, and 66% said no, they have not as of yet. We're going to go to our third and final polling question now. Have you received funds from the Paycheck Protection Program known as PPP? Please select 1, yes or no. And 46% have received PPP funding, and 54% have not. So again, it's about half and half. Well, thank you for participating in the polling. Like I mentioned, this will help our panelists understand our audience today. Now, it gives me tremendous pleasure to introduce you to today's panel. First, Elizabeth Sullivan, we call her Lizzie, and she will lead today's panel. She is Vice President of Government Relations at Madison Services Group, focusing on federal procurement, small business, and education policy. Her expertise in government contracting includes shaping federal acquisition policy on Capitol Hill and analyzing federal procurement data to position companies to win federal contracts. She is joined by Steve O'Malley. He is a government contracts and grants lawyer with Miles and Stockbridge. Steve assists private and public entities with contracts and grants compliance, government audits and fraud investigations, teaming negotiation and disputes, claims, and other matters relating to domestic and international public contracts and grants. Joining Steve is John Williams, who is a partner at the law firm of Polera Mazza and has over 15 years of experience advising contractors on a wide range of government contracting matters and federal acquisition regulation compliance, including the federal procurement programs for small businesses, the 8A Hub Zone Women-Owned Small Business and Service Disabled Veteran-Owned Small Business Programs. And last but certainly not least is Christine Williamson. She is a member of Cone Resnick's Government Contracting Industry Practice. She provides financial and accounting, consulting, and business services to a variety of clients, providing solutions to complex issues such as the development of indirect rate structures and tax ramification of acquisitions. Each of today's speakers serve on the Chamber's GovConnect Council, which focuses on policy and programs that ensures the success of government contractors. As you can see, you're in excellent hands today. So with that, I will turn it over, today's webinar over to Lizzie Sullivan, who will moderate today's esteemed panel. Thank you, Lizzie.
Thanks so much, Barbara. Thank you everyone for joining us today. Just before we get into section 3610, I wanted to say that one of the Chamber's advocacy goals during this time and always is to have specific relief for federal contractors. And that's actually why the federal advocacy team worked with Congress to get section 3610 put into the CARES Act. You know, it's not news to anyone that in times like these, whether it's a shutdown or a pandemic, people are usually first to think of employees. So the Chamber is always making sure in our federal advocacy efforts that contractors are not left out since, you know, they need relief as well. So basically our goal today is to talk about what is section 3610, as Barbara said, how can you use it to help get through this pandemic? And are there any outstanding challenges that exist around this provision? Before I get started with our discussion with our experts here today, I just wanted to give a quick overview about section 3610, since I believe half of you said you're aware about what it is and what the provision says. So first, I think it's actually important to know what the law says. So you bear with me while I read the slide, but here's what was actually in the bill. So it says, notwithstanding any other provision of the law and subject to the availability of appropriations funds made available to an agency by this act or any other act may be used by such agency to modify the terms and conditions of a contract or other agreement without consideration to reimburse at the minimal applicable contract billing rates not to exceed an average of 40 hours per week any paid leave, including sick leave, a contractor provides to keep its employees or subcontractors in a ready state. And you'll hear us talk a lot about that ready state part today, including to protect the life and safety of government and contractor personnel, but in no event beyond September 30, 2020. Such authority shall apply only to a contractor whose employees or subcontractors cannot perform work on a site that has been approved by the federal government, including a federally owned or leased facility or site, due to facility closures or other restrictions, and who cannot telework because their job duties cannot be performed remotely during the public health emergency declared on January 31, 2020 for COVID-19. So what this provision basically says, and the intent of it, was to give the government the ability to keep contractors and subcontractors in a ready state. So this is through allowing some reimbursement, which we'll discuss, for contractors to give paid and sick leave to employees or subcontractors in order to keep them in a ready state. So, i.e., if the employees can't telework because the nature of their work requires them to be on site, this provision is designed to allow them to seek reimbursement to keep those employees employed for when they're able to return to that site in the future and life goes semi back to normal. If you could go to the next slide, you'll see we have some links up here to guidance that have been put out for both the DoD and non-DoD, and we'll touch on these today. But I encourage all of you, if you have not already, to go look at that guidance as a federal contractor that has been issued, and also the FAQs that are there, which there's also on the slide, it says class deviation. And if you're not aware what that is it's a necessary deviation to allow agencies to deviate from the FAR and DFARs to implement a statute when basically the rulemaking process would take months and is too slow, and agencies need the guidance now. So that's what those documents are as well. So if you go to the next slide, I want to turn now over to my expert panel. I'm really excited to have with us today. And I have quite a few questions, but I can see people are already typing them in the question box on your screen. If you could do that, we'll try and get to them as well. So to start off, and this is, for anyone who wants to answer, I want to talk a little bit about the basics and how contractors can take advantage of 3610. So my two questions to start off are, specifically, if I'm a contractor, do I have to get approved by the government to bill under 3610 authority, and can I utilize it if my personnel are not performing the critical national security functions? Whoever wants to start.
Well, I'll jump in just to take the first one, maybe to kick things off. Yes, you do need approval from your contracting officer to do this. So that's something that we've gotten a lot of questions on. You can't just start doing it. It needs to be cleared ahead of time. There'll be unique considerations and unique ways it might be implemented depending on what type of contract you're on and the nature of the work that you're doing. But it's the government's discretion to determine that it's in their best interest to do this. So it really is almost a sales job at a certain level to convince the particular contracting officer to approve you on that contract to bill under this authority.
Yeah. And
Yeah.
go ahead, Christine, you first.
Well, I was just going to mention that you should check your agency and what their guidance is, because many of the contracting officers are now receiving from their contracting activity shop, they're receiving templates and letters and certification guidance that they are providing to the contractor. And so it's really important for, just like John said, to even sometimes notify your contracting officer, because they may not know. And so it's ever more important to be talking to your contracting officer about how your employees are doing, how they feel, are they sick, are they working at home, and would you need that additional funding? Go ahead, Stephen.
Yeah, I was just going to add to John's point as well that if you look in particular at the implementation guidance issued by DoD, they did a good job of sort of drilling down on that concept of how you actually go about asking, and it really depends on the type of contract you have, right? So if it's a fixed price contract, you essentially need to set up a separate CLIN through an REA process, which we'll talk about. If it's a cost reimbursable contract, I mean, you've already got the allowable cost clauses in your contract. So what you really need in that instance is just authority from the contracting officer that you can start seeking reimbursable for these now sort of newly allowable charges. So there's a different mechanism. The actual document the government's going to hand you might be different depending on the type of your contract. But John's point's exactly on point, that you have to get that document or that approval. And then the other thing I was just going to sort of jump on top of is the concept of the purpose of this, of 3610. I think that might be a good place to sort of get the 10,000-foot view for everyone, because there are all of these different COVID-19 responses that Congress has authorized, right? And 3610 is just one of them. But we should think about what is the intended beneficiary of each response. And it pretty much comes down in two buckets. It's either the government or its employees. So PPP, for example, is supposed to benefit employees. It also benefits the companies paying employees, but that's, the idea is that we need to be paying payroll costs. 3610's actually about the government more than it is about contractors. It's all about that ready state concept. So when you're doing a sales pitch to the government, the idea needs to be, so I'm eligible because I have people who can't work because of COVID-19, and we'll talk about what that means also. But then the other part of that sales pitch has got to be, you want us to keep our staff in a ready state. So when they can work again, we don't have to then spend 30 days trying to staff up because we've had to lay people off, right? And so it's really a sales job as much as it is any other sort of eligibility determination.
Yeah, you can't apply for it. It's not like the PPP. You can't apply for it.
Right.
But let's
Well,
talk
how about
this other question, because I think there's not necessarily clear guidance on this, but I have a view on, I think your second question, Lizzie, was what the nature of your work is not, quote, critical national security work. I mean, I think as Lizzie read the statute, that's what it's geared towards. And when you look at the guidance that was linked, and to Steve's point, ready state, and there is certainly a national security component of that. But from my perspective, they've got a lot of discretion. This is, in a way, almost like the novation process, if you're familiar with that, that if the government decides that it's in their best interest, they'll do it. And if they don't, they won't. And it's really like, that's the end of the story. So I think if you can make a case, and you probably do want to try to connect it to a national security interest as best you can, but it's discretionary on the part of the government. So I think if you can sell it and they're willing to do it, then it's possible that even if you're not in what you would maybe traditionally consider to be a national security field.
Yep. And
So what about subcontractors? Sorry, go ahead.
No, that's a great segue. But if you look at the actual language of the act, it doesn't limit its applicability to national security only. It's just ready state to support the government. Now, clearly, if you look at like ODNI's guidance, right, the intelligence community's guidance, they are clearly the most aggressive in looking to hand out 3610 relief. I think after that you see DOD, and then after that you look at GSA, and that just makes natural sense, I think. But doesn't mean anyone can't get it, right? So subcontractors. I don't want to hog the answer to that one, but that's clearly subcontractors are eligible. The process by which you can recover costs that were incurred by your subcontractors, that's a little bit amorphous. I imagine Christine or John have other sort of thoughts about that, but I would just leave it at that. It's I think there's a little bit of a TBD there on that exact process, and it will likely be idiosyncratic to each CO and each kind of subcontractor relationship that the CO is then revising or reviewing rather.
Well, hopefully, John, we haven't talked about this, but you would agree that if you're a sub to a prime, you've got to go through the prime, to get this 3610 funding. So it's another sales job to talk to your prime contractor. And if they are getting 3610 money, you need to know if that's going to be applicable to you. And I have contractors now that are working with their primes to get that 3610 set up. What else have you found about that, John?
No, I totally agree. And we have clients that are in the exact same situation. And, it sort of harkens the claim or REA situation as a subcontractor, right? You need your prime to essentially sponsor your claim through to the government. And it's really a similar situation. So do you have any contractual mechanisms in your subcontract with your prime that you could push that button in order to facilitate them to do this? But you are beholden to them. Even if you have that contractual button, it may not be working when you try to press it, depending on your prime. But hopefully the primes, because they're probably in a similar situation, are willing to work with the subs, and that's what we've seen by and large to this point.
Yeah, and I would add that some parts of this make it easier than the traditional sponsored claim situation. Some parts of it make it harder. I think the part that makes it a little bit easier is what John just said. I think where there is a 3610 eligibility at the sub level, there's almost certainly going to be a 3610 eligibility at the prime level, right? Because you're probably working in the same office that's been shut down. There might be a few exceptions to that, but it's generally speaking going to be the case, which can be contrasted with the typical sponsored claim situation where sometimes the sub has the claim, the prime doesn't have it at all. And so the prime is sort of looking for, what does this mean to me? At the same time, though, 3610 doesn't allow profit recovery. So the prime is going to be sponsoring you without a lot of upside for itself. So that is, again, where there needs to be a sales job and a sort of meeting of the minds about sort of the mutual benefit to the program as a whole. It may not be benefiting the prime's bottom line, but it's certainly to keep their sub labor in a ready state. It should be beneficial to the program.
Mm-hmm.
So actually, it seems like a subcontractor is asking a question. Jason, he said, what about employees on a green card that are not allowed to work remotely? Our prime is saying we cannot get approved to use 3610 to cover this employee's time. Does anyone have any insight on that?
There is part of the question and answer about employees that work outside of the United States. I'm not sure that must be that they're here working on a green card. If they're able to charge on a government contract now, I don't see how that would change the ability.
Yeah,
I'd agree with that. Yeah.
I would, this implicates sort of another, sort of almost a constitutional concept here, that because this program is discretionary, there really is no way, it's just like novation. John's analogy is perfect. You know, when the government denies you novation, do you have any real recourse at law? Generally speaking, not. I mean, I think the cases where you could have recourse would be extreme outliers because the government's making a best interest determination, and they generally speaking have almost complete discretion to determine what's in their best interest. So I would agree with Christine and John that somebody who has a green card is not clearly ineligible for recovery. This is a person who's unable to, on a government contract, who's unable to work because of the COVID crisis, presumably. There's no per se ineligibility, but if the government declines that ineligibility for, I think for any reason almost, it would be difficult for you to challenge that declination because of the fact that the program is at its outset and at its core a discretionary program, which is I think frustrating probably for the person who asked the question and probably for a lot of you, but it's sort of where we lie. And that's why the three of us have kind of been emphasizing the sales aspects to this program.
Okay, so say you go to your contracting officer, you make this sales pitch, right? You make the case for relief and you don't get the answer you wanted. You get a no. I've heard a WSB told me that she tried to do that for one of her employees who couldn't work remotely, was in a skiff. And the CO's response was, well, we're just going to cut that position then out of your contract if you try to seek relief. So what do you do next if you get a no? Do you have options?
I mean, you do. They're not necessarily great options, is my answer. I mean, they're the traditional options that you would have. You know, when somebody, if there's a unilateral deductive mod against the contract, that gives rise for a request for equitable adjustment related to things like unabsorbed overhead, typically, and things like that. But that's you know, is that a particularly useful remedy? Not always. But you know, going back to my earlier point, subject to what John and Christine think, is you know, you either need to go back and try and get them to revisit that determination through other facts that you might be able to introduce. Otherwise, you're going to be stuck with that determination.
Yeah, I was going to say, and I recognize this is easier said than done, like try again, try in a different format. Maybe the second time around, it's a polished submission by your outside advisor as opposed to however you handled it.
I think we've got some.
John froze. John froze a little bit.
He paused.
Where he's going with that, though, I mean, the reality is that it's silly as it sounds. Dotting your I's and crossing your T's and making your requests look really eloquent and informed and citing the right version of the guidance can go a long way. It's sort of the old rule of thumb.
I think the OMB guidance puts an emphasis on the difficulties that small face.
Well, and you know what? While he's trying to come back on, I think one of you made a great point that.
You guys there?
Yeah, we're here, John, and I'll let you go.
We're here. You were just freezing.
Yeah,
a little bit.
Something, and then I'll let you go. But you know, as time goes on, the contracting officers are going to be more comfortable with this and have more understanding. Now, we only have until September 30 right now, but you know, I think the going back to the well is a good idea with a more educated explanation and reason, you know, on why you are an affected contractor, why you still need to be working. So hopefully that helps that person. I don't know if John's back, Lizzie. I don't see him, but maybe do we hear him? No.
Well,
Okay.
I would also, while he's trying to get back, I would recognize that folks got to make a decision soon, right? Whether or not to furlough somebody. It's difficult for you to want to carry, you know, payroll costs, particularly if you don't have PPP and you're not getting the FFCRA credit for whatever reason, particularly maybe if you're a large business, for example. I mean, you're going to end up dealing with the possibility of carrying these payroll costs, and there's this amorphous possibility that 3610 will be given to you. So obviously everyone's in a better position if they can get that CO buy-in up front. Otherwise, you're gonna have to start making decisions about your staff.
Or they could, Lizzie, the person, you could apply for the EIDL, the Economic Injury Disaster Loan. They did put more money into that with the, CARES 2.0 additional money. So, that could be a possibility for that person.
Yeah,
To keep that person on board.
you'll get a $10,000
So on the,
program, but go ahead, sorry.
I was going to say, yeah, there was more money in that, and that hasn't restarted yet, but I know SBA is working on it. But on the flip side, okay, say you seek the relief, they say yes, what's next? Because I've heard document, like Christine, what am I supposed to document? Steve, what am I supposed to do? So say I can get this relief, what do I do next if I'm a contractor?
Well,
yes.
Yeah, I mean, so you're talking about after you've been approved, right? I think John's back.
John's back.
Sorry about that.
Hi, John.
I lost internet.
No problem.
So we were Lizzie just asked, what the sort of documentation for actual cost submission is, right? And so up front, you don't need to be submitting certified documents. That's what the guidance says. You just need to essentially state your potential entitlement based on facts around the circumstances of your contract labor. Then later in time, when you actually invoice for those costs that you incurred, then you essentially do the kinds of things, if you were on a cost reimbursable contract, for example, that you would do to substantiate the payment of those costs. Under a fixed price contract, things are a little bit different, but you're looking at the same sort of items, payroll, the proof that you actually paid the employee what you're claiming that you did. There is some guidance out there that varies agency to agency, but what I've seen, subject to what you guys think, is that the common thread of all guidance is that talk to your CO. They will figure out how to do the cost accounting. Is it indirect, direct? How do you allocate it between different contracts? What exact proof is going to be required? It's kind of hard to advise in a vacuum because of that. But I'll digress.
Okay. Yeah, so Lizzie, just kind of a little bit of the nuts and bolts. Most of the time when you get a separate task order, you get a separate CLIN, you're doing something different, you set up that separately in your accounting system. So you want to do that right at the start. Most government contractors, for generally 99.9% do timesheets. So, we're mostly talking about the services that a person is performing, obviously. So you want to set up that separate time charging to whatever contract, that this is applicable for, and it would be to each one. And if you have to set it up by CLIN or acronym, again, talking to your contracting officer, because they're going to see the billing that you do for this. But you definitely need to be able to separate this from other cost, especially if you have the PPP loan. So just like they're saying, document. When you go to the implementation guide that Department of Defense has set up, they've even gone as far as said, here's what you call it. Call it other direct cost COVID-19. On a fixed price contract, they wanted it named something different, which was called labor force retention COVID-19. So whatever you're going to do, set it up separate. You can use these same descriptions in your contract, and then be able to approve it later. Is the most important thing. And we're really not seeing, there's questions out there right now about whether it should be charged indirect. For us, we suggest that it's probably all going to be direct. It's going to be charged to a contract. There's a little bit of guidance out there that's confusing that says it could be indirect. We're concerned about that because that could change your indirect rates, increase your fringe rate. It might not be applicable to all contracts. If you had one contract, then yeah, I could see that working. Or one agency with multiple different contracts that they look at the funding all the same. But probably more people are going to be charging it direct than indirect. Is going to be only in certain circumstances.
I have, thank you, questions around, like, for a fixed price, is there a separate CLIN? And for a cost reimbursement, do you invoice the cost? Like, very specific questions. So as a contractor, when do I come to you all? Like, when do I go to my procurement attorney? When do I go to my accountant? Like, is it before I submit to my CO or talk to them? Is it after? Basically, when should I consult my experts?
I always say earlier the better. I know that's probably a self-serving statement, but I would generally tell you that for every person that comes to me before they even submit a request for 3610 reimbursement, it will end up saving them legal fees in the long run. Because I could look at and talk to you for an hour and generally speaking, tell you what you're doing wrong before you make the mistake, or at least give you some assessment of your area of risk before you make a mistake or before you incur that risk without knowing you were going to incur it. And then, you know, if you go ahead and do it and something goes wrong, you're looking at many hours to fix a problem as opposed to 30 minutes or an hour to avoid one. So that's generally my rule of thumb, particularly on this program. The PPP program, even more so than 3610, because at least the 3610 concept, you're just setting up the CLIN at first. And then when you bill against it, that's when the real penalties can really lie, because that's when you're certifying that you incurred these costs and that they were allowable, et cetera, under these various CLINs. But still, I would want you to come up really early in the process. And again, just to sort of throw a bone out to PPP, anyone who's applying for PPP should definitely be talking to a lawyer before they do it. At least a short conversation. Leave it there.
100% agreed.
Okay, thank you. That's helpful. Another thing then, now that we've kind of covered the basics, I want to know, so selfishly from a policy perspective, since you've been working with clients, has anyone really successfully used this 3610? Oh, that's my dog. This 3610 reimbursement. I know that I think 46%, or no, 34% said yes, they've discussed it with their CO. Has anyone successfully used it? If so, how? And if not, why do you think they're not being successful?
I have had a number of clients successfully get through to the CO to agree that 3610 will be reimbursable. I don't know if they have actually received $3610 in their bank. So that's something, you know, Christine?
Yeah, I think, you know, we were talking about this before that, Lizzie, it's pretty much starting around mid-March when Trump announced this was a pandemic. Here we are, April 29th. By the time the guidance came out, you know, April 8th and 9th, we're just starting to see these Excel schedule templates coming out from contracting officers to the contractor to fill out and put the reasons. So I would say probably, you know, the 1st of May is when we're going to see people, Stephen, that are going to be billing for this for the first time.
That's right.
I went into the spending obligation of COVID last night, which we're up to 8 billion now, by the way. And in the COVID obligation, it's very interesting. The contracting officer has to identify COVID-19 2020 as the description for the services. And then if they issue 3610, it's in a separate description. And I've found 3 that have been issued that at least have been put into the system by the contracting officer. And these is across all agencies. And they say that they're behind putting these in because, of course, contracting officers are working at home as well. But
Yeah.
But it is out there. We're probably going to start seeing the billing in the next couple of weeks, Lizzie.
That makes sense. And that, should we just go ahead and answer that one question that we were talking about before the webinar began? And that's the concept of what time should you be able, like, are you eligible to be able to charge to the government? Like, on what date does
Perfect.
3610, yeah, like eligibility start? And, you know, I as like the, you know, pedantic lawyer on the call was like, well, the act doesn't specify. So in theory, it should go all the way back in time to January 31st with the declaration of national emergency. And it just sunsets on September 30th pursuant to the act. But I think there was a really great point that you raised, Christine, about how, well, no one would have worked from home out of necessity until roughly around March 15th, right? And I don't want to steal your thunder, but that was kind of, I thought, a very good point, because it essentially meant that, oh yeah, no one's going to be able to certify probably eligibility for 3610 reimbursement until that date and time when government offices actually started shutting down and people actually started being required to work from home, right?
Right.
And then we're not able to because the contract doesn't allow it.
Right. And Department of Defense is the first one that came out with that guidance, and then the rest of the agencies follow suit. But you need to check with your agency because they may have a different date. Isn't that right, Stephen? Did we see a different date in a couple other agencies?
And they're all over the place. Yeah, I mean, like OD&I said you can go all the way back to January 31st because OD&I is, I think, very concerned about contractor workforce. Understandably, as you can imagine, the intelligence community needs to be maintaining a ready state. And DoD kind of has like I would call it a slightly less urgent, but still pretty urgent piece of guidance, and where they're talking about sometime in March. And then to my recollection, having looked at the GSA guidance, which came out most recently, it's kind of ambiguous. And I think that just shows their level of interest in administering $3610 and how important they feel it is to their agency's mission. But in any case, I think you're right, Christine. There's a lot of conflicting guidance at the end of the day. I hope it's just probably as far back as March 15th. That's where I hope everyone settles, not just DOD. And I think that's about as far back as you could reasonably go where you start to actually see shutdown orders.
Well, you all will find this interesting. I was actually going to talk about that because Lisa has said to us, my CO has directed us that we cannot submit requests for the days prior to March 27, authorizes reimbursement only. She then quoted what it said, but yeah, apparently her CO said only March 27. So just as we discussed earlier, it seems that there are kind of some discrepancies on what COs are saying when you can reimburse back to. So I also have a lot of questions. I want to dive into talking about the Paycheck Protection Program, PPP, and its intersection with 3610. I know that it said 46% of the people on the call have received PPP funds, which is great. But as a contractor, just from a 10,000 foot view, am I able to take advantage of both 3610 and PPP? Do I have to choose which one is better? Let's start addressing some of those questions.
I have been advising on this subject for probably 15 to 20 hours a day for the entire month of April. All right, you can probably see the bags under my eyes. I feel like I know about as much as there is to know about this. I'm sure I'm wrong about that, but I've definitely read so much and talked to so many people. And I don't have a completely clear answer to your question, unfortunately, Lizzie. However, I've got some things that I think and things that maybe Christine and I can talk about and how we interpret the guidance that's been issued. So the most important piece of guidance that we had on this, so originally we thought, yes, of course you can do both. You can't double dip, but you can still do both, right? And there's this requirement in the PPP loan program that you can't take another type of loan, like an idle loan for the same purpose. That's okay, that doesn't affect us. And there are all these other sort of minor ambiguities that we can talk about. But I think the bottom line is, at least we thought, and we still do think, but I'll take you through the process of our thinking over the last couple of weeks because it's evolved, is that you can do both. Then DOD issued this Q&A, and I forget the exact number. Yes, Q&A 23 that was issued originally on the 17th.
Special number 23.
Yeah, special 23, and then it was updated because I think somebody got through to them and said, whoa, 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 you're causing a series of panics within the contractor community, and they updated it on April 24th. So they updated it 5 days ago. But the takeaway is that DOD is saying that where you have got loan forgiveness on the PPP program, that would be essentially a COVID-19 grant that is similar to the kind of grant, lowercase g, that we're giving you here under 3610. And so therefore, if you take both, you have to credit back the government using some cost mechanism that Christine will maybe be able to tell us more about, for the amount of forgiveness that was allocable to the money that you received from the government for your 3610 eligibility. I'll stop there. Christine, everything to add? There's so much more to dive into on that subject, but the answer is yes, you can do both, subject to some caveats.
Yeah, and I think what's sort of missing in some of the FAQs, and maybe some more things are going to come out, is, making sure that people understand during the 8-week period that you have the PPP, that's if you're funded with 3610, I really think that's when the intersection, is, because if you get 3610 later, then one would assume that I would be able to collect on that, up through whatever time period that goes. But what this leads us to, Lizzie and Stephen, is that more charge numbers that have to be developed in your accounting system. And this is for, across the board. This is for your entire company, your indirect people, the direct people, on different reasons why they can charge and why they can't. But it is really confusing still as to where the credit is going to be applied. Is it going to, do you even send a bill in, or do you send a bill in, and show that credit? I think that's going to be specific to each agency possibly as well.
Yeah, on top of that, I would add sort of like, let's talk about one area of ambiguity, and then let's talk about some best practices there, I think. So the area of ambiguity I wanted to highlight is how much of somebody's salary can be reimbursed here. So obviously, everyone who's familiar with the PPP loan program knows that payroll costs are capped at $100,000 per employee, plus, as we've now since learned since the act was passed, plus healthcare benefits, retirement costs, and state and local taxes, right? So maybe slightly more than 100K on a prorated annual basis. But when you get $3610 on top of that, can you cover the difference in somebody's salary? I mean, a lot of government contractors, particularly in the DC area, a lot of employees are going to make well over 100 grand, because that's just market for particularly people with security clearances in DC. Can you cover somebody's entire salary by a combination of both PPP and 3610? I think the answer should be yes, but it is not 100% clear, right? As long as those two sources of funds are not covering the same amount of the same dollar number. And so then the practical sort of concept that I wanted to talk about, which is, what do you do first? What do you bill first? I think there's a bit of a logic to this. If you've been getting 3610, you can still get PPP, right? And then whenever that PPP forgiveness comes in, that's when you issue the credit back to the government. If, however, you've been holding your 3610 bills because maybe you've got the CLIN set up and you don't need to invoice immediately, that might be the smarter, easier way to go, because as long as your CLIN allows it and your contract allows you to bill more than 1 month in arrears, right, that you could just save it up until sometime in this summer to bill your 3610 costs, you might want to sort of wait and see what you're going to get back on the PPP program, so you don't end up billing and then having to issue a credit. You can just do all of the accounting after your PPP forgiveness has been settled, and then just submit one 3610 invoice showing the PPP forgiveness, and thus truing it all up all at the same time, being transparent. So that's the last thing I wanted to emphasize, is transparency.
Okay. Well, and because the forgiveness should be calculated like 8 weeks after your 8-week period of your PPP timeframe. So yeah, there's more that's going to come out on that, Lizzie. And I know we've written a letter to find out, more. We're working with you on just if that is possible, that you can pay the people who over and above 100,000, if you can pay them with 3610 money at the same time during your 8-week period, because your protection plan program loan is for cost incurred. So you have to pay for those costs after you incur them, but they're only for the costs that are incurred from the date of funding through 8 weeks.
Right, and as you said, that's something the chamber has really been spearheading, which is trying to get more clarity from on both the DoD and non-DoD side for these very specific kind of billing in the weeds questions that require, a little more in-depth knowledge and a little more clarity. And I think you actually answered, I'm getting a lot of questions rolling in, so I'm trying to field them. Something from Rodrigo, who said, how do we keep track of PPP? Should we create a new earning code on our payroll policy and call it PPP? It seems like I'm getting a lot of these types of specific questions.
Yes. So what we are advising folks, and I've been talking to other professionals that do the same thing, outsourced accounting folks, other accounting firms, is to set up a separate project number for PPP for your costs that aren't under 3610, but that you believe are going to be forgiven. If they come out and say, you know, that government contractors can't be forgiven for all their other work that they're doing. But if you actually have direct charge folks that can't work on remote contracts and that can't work on 3610, set up a separate project number to hold all of those costs. So these are possibly could be indirect folks as well that can't work. And so you want to set up separate charge numbers for them as well, because if you need to show to the government what you were paid for and what you weren't paid for that you want to have in your loan forgiveness, you need to be able to show all of those costs in one area. So their labor, you could move their taxes there, you can move the health insurance that's allowed, 401k. So we are suggesting some sort of a project that you can isolate those costs that you aren't being reimbursed for. Hopefully that helps everyone. And I know my contact number will be here afterwards, but most companies are seeing that this unbillable or kind of unallowable separate project is a good way to do it, because most of them have cost accounting systems, you know, that will handle that.
Steve, anything to add on that?
No, that makes perfect sense to me. I think even if it didn't make sense, I would still just listen to Christine on that one. But it does happen to make a lot of sense to me. Yeah.
Yeah.
I think that comes back to the
can't work. Right. Go ahead, Lizzie.
Yeah, no, I was just gonna say, I think that comes back to the whole advice that I've heard from both of you, which is kind of that document advice. I think that just touches on that very well. We had a question also, since we're on the specific cost conversation, from Sam that said, for FFP and labor hour contracts, are Section 3610 reimbursements limited to only direct labor costs exclusive of OH/G&A and fee? I don't know if that's
definitely
specific.
Not fee. Yeah, you can't include overhead, but not fee, right?
Right. It's overhead and G&A is what he's talking about, Lizzie. OH is overhead and G&A.
Thank you.
Right.
Yes.
Yep.
So on the cost plus job, you know, you're going to calculate that with your regular effective hourly rate of that person, and then your burdens, which is your overhead and your G&A. Your fixed price will be whatever is agreed upon for that fixed amount for that time period that the government feels like, you know, you're the affected contractor on 3610. And then on the T&M, I would assume that they would be picking a time and material billing rate that is within your contract already by some labor category. And that would be used for that, which should already include the burdens, the overhead, and the G&A, but you would have to exclude fee in any category, in any case.
So that's why there's a little bit of ambiguity. And I myself have wondered this, and I'm looking for more guidance on it, but I think the guidance is going to ultimately be, here are the principles, negotiate with your CO, which is frustrating for us, but it's probably where we're going to end up. And I think the most complicated example is fixed price, right? You're going to get a fixed price plan that's going to be an hourly rate, I guess, even though I don't know how that's fixed price, but that's kind of what the government said. If you look at, the best thing for you guys to look at is the implementation guidance from DoD that actually identifies what their guidance is per different contract types. And I think we had it in the first slide, Lizzie, I think we did, or the second slide, I think is what it was. But it goes through and it talks about fixed price contracts, but it says weird things like, it talks about multiple contracts requiring multiple reasonable allocations of costs. And it also talks about ensuring that the payments made just sort of recover costs of providing paid leave and shall not increase profit. So, I mean, a fixed price presumably increases a profit, has a profit component to it. So I think when you're negotiating that CLIN, you're probably going to have to provide something that looks like other than certified cost or pricing data in order to support whatever you're setting that CLIN at for fixed price billing. Now, clearly, I would, I'm sure Christine would tell you, are they going to ask for certified cost or pricing data? I would hope not to set up something like this. But, you're going to probably need to substantiate your G&A, your overhead. So you're essentially, no matter how you're doing this, you're kind of building up a fully burdened rate. Even though that fully burdened rate might then get stuck into the contract at a fixed price level, as a fixed price payment mechanism, it's still gonna, I think, supposed to look like a fully burdened set of costs that doesn't include profit. But anyway, that's just all I can sort of tell you right now, I think.
I understand that John is back with us. He's just on the phone. John, feel free to interrupt us at any time. Is there anything you have seen or want to add around PPP and 3610 and using both of those together, or shouldn't use them? Anything you wanted to talk about?
Yeah, I mean, I hope I won't be repetitive of what's already been said, and apologize that my internet decided to go on paid leave right in the middle of this presentation. But yeah, I mean, I see no reason why folks shouldn't be going for both. I know that we talked about the double dipping, but we don't have a double dipping issue unless and until the PPP loan is forgiven, and who knows when that's going to happen. We don't have the forgiveness guidance yet. I know it was mentioned that PPP is for 8 weeks, 3610 authorities through the end of the fiscal year. So I think as much as you can, try to use them in tandem. And, to the extent that they are ultimately used for overlapping costs, then, you'll have the expectation that you'll either not be seeking forgiveness or you'll have to credit something back to the government to avoid the double dipping issue. But I think everybody that needs the loan, and that's an important piece to emphasize given recent guidance and what's been in the news with the Lakers and Shake Shack, et cetera. But everybody that needs the loan should be pursuing it, and I think should also be pursuing 3610 authority if it fits your circumstances.
Thank you. And one more layer to add on to that, that was a question from George, that is FFCRA leave not covered under 3610? And can you all kind of talk about what FFCRA is and what he's asking?
Sure, I can start out. And this is the additional sick leave and family leave act extension. This is the second tier of the COVID-19 stimulus that came out from the federal government. And really, money came out first. There's $8 trillion that came out to start getting ventilators and set up hospitals. And then the second was let's make sure that we can still pay our workers. So they required companies to give sick leave and also additional family leave act. So you can't double dip on that as either. So if you receive a credit, that's what you will receive through the FFCRA, you would have to, you would not be able to also recover that with the PPP or with 3610.
Yeah, I would also observe that I don't know how much overlap there's going to be between the two, right? This isn't like PPP where you are definitely going to see some overlap. FFCRA, and I'm not an L&E law, I'm not a labor and employment lawyer, so this isn't really my breadbasket, but it appears to me that those tax credits are for paying people who are unable to work because they are sick or caring for a loved one who's sick. And that is not the same thing as being able to get 3610, where you are able to work, but you can't because of federal government shutdown, essentially, on the COVID crisis. So, and also because of the nature of your work being something that cannot be done remotely. So I see those two buckets as largely separate. To the extent you think you have any overlap, it would be a highly strange factual scenario, certainly possible, I think, hypothetically maybe, and you should definitely talk to your advisors about that. because it will be a unique situation.
Well, thank you. I know we're running out of time, so just to wrap up our session, I want each of you to leave us with your one either best practice or, key piece of advice for the contractors on the phone regarding Section 3610.
Well, for me, I mean, I'll just bookend what I said at the outset about it being really about a sales pitch. Like a lot of other times you use that muscle when you're interfacing with government customers. This is another opportunity where you need to sell them on this. And we've seen packages put together by clients, and we've assisted with them that include letters from the impacted employees that really need to stay at home because of what's going on, or the challenges that they would face if they were laid off, and the benefits that it would bring to them and their family if they are able to get this paid leave. I mean, there are a lot of different approaches there, but really focusing on the fact that you need to convince the government of this. They're not required to do it, and in some cases might be skeptical or at least unaware about how it works and the fact that they can do this. So really focus on putting your best foot forward in selling your need for this right out of the chute.
Yeah, the thing that I would take away, just piggybacking off what John said, I agree with everything he said, but I would also add transparency of purpose and of facts is the most important thing you can do in order to avoid any sort of accusations of impropriety. So what does that mean? It means that when you apply for a 3610 CLIN, you should make it clear that you also have perhaps PPP dollars in the hopper, right? And that you will either be granting a credit or not billing against 3610 to the extent you get PPP forgiveness first, or not going for PPP loan forgiveness to the extent you get backwards. You're not going for 3610 to the extent you get PPP, and not going for PPP to the extent you get 3610, right? So I just think that you need to be documentation heavy and full sort of, open kimono with the government with respect to how exactly you're pursuing your COVID-19 relief strategy. And that would also include the same thing with your primes if you're a subcontractor. So I've seen a number of primes ask subcontractors for information about all of their various COVID-19 recovery strategy uses. And these subs come to me and say, hey, the prime's kind of like asking for all this information. I don't want to provide it to them. Well, my general advice is that, well, they need to understand what you're eligible for, because when they make a claim for it, they might be certifying the authenticity and accuracy, completeness of that claim. So in many instances, I think prime's interest in the information about their subs is generally speaking legitimate. But again, everything's idiosyncratic, right, to its own facts. So I would recommend you talk to your advisors if you have a particular concern.
And I would just leave, Lizzie, something we haven't talked about, but it's all about cash flow and getting your bills out correctly and looking at projections of your business. So, take the time to do a couple of scenario what if with your company, and then you will be able to tell your contracting officer if you are going to be affected, and that maybe some of your other programs won't allow 3610, but maybe another one will. So I think doing those projections as a company is very important, and that will help you decide if you should go after the 3610 funds.
Well, thank you all so much for taking the time to, share your expertise today and answer a lot of questions. I had a lot of questions that were specific to PPP. If we didn't have the chance to get to yours, I know that the Chamber will be sharing contact information, and they are also a great resource. And before I kick it back to Barbara, I just want to say that the Chamber is continuing to advocate on behalf of federal contractors to get relief during this time, and really trying to seek more guidance on Section 3610. With that, Barbara, I'm going to kick it back over to you.
Thank you so much, Lizzie, Steve, John, and Christine for this important presentation on Decoding CARES Act Section 3610 for government contractors. I know you all are working tirelessly on behalf of your clients and really the national interest here of our industrial supply chain when it comes to government contractors, and work very much on their behalf through GovConnect Council. So thank you so much. And John, I'm sorry you had some difficulties with your internet. Hopefully you'll be back up, but I certainly appreciate you willing to just hang in there and dial back in. So I know we'll have you back for more. And I want to thank our participants for attending today's webinar, and to the SBA and the Montgomery County Chamber of Commerce for making this webinar possible. As we mentioned at the beginning of today's broadcast, a video recording of this presentation will be available later this afternoon on the Chamber and VIP's Coronavirus Resource page. And the slides from today's presentation will also be made available to you following this broadcast. And any questions, as Lizzie mentioned, that we didn't get to, we will seek to get those answers and send those out to you when they're made available. Thank you again for your participation today, and we wish you, your families, and your businesses health and success in the months to come. Thank you all, and have a great afternoon.